Hi, everyone, and happy Friday. Thanks for joining us today for Privacy Chat. Today, Jules is talking with FPF's Dr. Sara Jordan, Senior Counsel for AI and Ethics, about the recent developments in artificial intelligence in the EU and our upcoming session on AI and governance next week. And that's on Thursday, and you can register for that at fpf.org/training. Jules, take it away.
Nancy, before you go, I got to ask you a question.
Sure.
I was on a meeting the other day and someone said, do you know who you look like? And I said, I don't know. Said Mandy Patinkin.
Oh.
I don't really look right. It was just a beard. You don't really look like.
I could see that. Maybe a younger Mandy Patinkin.
Thank you. You see, this is a good team member. A younger and handsomer version. Oh, she didn't say that, but a younger version. All right. Thank you. Sara, thank you for joining me. Before we talk AI, we got to at least mention the news of the day, which really ought not to be the news of the day because I think it's not really such big news. However, the court in Ireland, which we are all following to see what happens, the next steps in the Schrems decision, the decision from the Court of Justice of the European Union that determines what happens with data flows around the world, the US, but around the world. Well, we had a decision today. And what does it mean? So maybe just a word about that. So if people recall, when the Court of Justice ruled, it invalidated the US-Europe Safe Harbor, Privacy Shield, as it's called, which 4,000 or 5,000 companies use. It didn't invalidate. It said the standard contractual clauses are still valid, but that's only if perhaps they have appropriate safeguards, and we don't really know what those safeguards are. And many think that, in effect, you don't really have safeguards that would keep the data from surveillance authorities, but this is to be determined. In any event, the case went back to Ireland for Helen Dixon, the DPC, Data Protection Commission of Ireland, to decide what to do, how to implement the court's decision. And what the DPC did is something that initially created a lot of controversy. The DPC said, okay, but I'm opening up my own case against Facebook, an own volition case, as opposed to this case here, which had initiated from Schrems filing action, which is why it's the Schrems case. And that case and the return to her, which is still on their plate, she said, I'm actually going to open up a new case. And people got upset. Wait, you have a case. That's the case. The court just sent you back the case. The European Data Protection Board said, wait, what's going on here? And there was a lot of criticism. Well, it turns out that one of the early steps in this new case was to actually draft an opinion, a draft decision, and it hasn't been publicly released, but it leaked, and Facebook was provided with it or got it, and they immediately sued to prevent her from proceeding in this direction. So we understand that that draft decision basically says, Facebook, you may not move data. We don't know how broad it is. Is it only Facebook? Is it everybody? But in any case, and Max Schrems was very angry. He, because he said, hey, you have the Schrems case. You now should move and freeze Facebook data because the Court of Justice told you to do so under the Schrems case. But the DPC said that case was actually brought under the directive, and it's old, and the GDPR is now in place. I'm going to bring it so I can take fresh evidence, hear both sides, and I can actually then make a decision under the GDPR, and that'll be a better case. Well, it turns out the court agreed with her. The court said, yes, you can, despite arguments from others. Schrems, he settled actually, so he wasn't part of this decision here at the end. He said, okay, based on a commitment that they will keep him involved, that if the court approves, he can be part of this own volition case. And in terms of the Facebook, no, Facebook, you have no right to try to prevent this from proceeding. So the next step is that she now will hear from both sides. We'll hear from Facebook about the draft, make a final decision. She can then must send this to the EDPB. They'll have a couple of months at least, or maybe it'll move quickly, but typically it takes them a while to agree, to try to conform. And then once it's final, Facebook may yet appeal and argue that mistakes were made and that under the GDPR, they actually provide appropriate safeguards, or maybe rely on other derogations. So nothing really, really new, a procedural step, but it's making headlines because, you know, the next step in the Schrems case, although technically this is not the Schrems case, this is the DPC versus Facebook, using the implications of what happened in the Court of Justice. Okay. Put that aside for the moment, and let's turn to the AI issues. So you have been following not only, of course, the new draft proposal from the European Commission, but you've been following the state efforts around in the US around automated decisions. There's obviously already GDPR language around automated processing and so forth. Coming to this with a deeper background on machine learning than perhaps some of the lawyers who know data protection, but maybe haven't been deep into understanding models and neural networks and the different kinds of processing. What are the kinds of things that the privacy, the legal, the CPOs, the DPOs are going to have to understand, really about the technical, the governance, in order to figure out how to manage and intersect with these laws? What are the concepts that people are going to need to really maybe understand a little bit more technically than they do today?
Sure. I guess I would start by saying, gosh, isn't Europe interesting right now, right? There's so much going on in terms of those regulations, and obviously what you're just outlining in terms of the Irish DPC. There's a lot to pay attention to out there in the world, but within your own companies, you're going to have to figure out what to pay attention to as well. And as you just pointed out, there's a couple of sort of signal areas and signal concepts that it's going to be important to take a good inward look at. So, for example, your information architecture. How is it that data gets into your company? How is it combined? How is it recreated? How are features made? Do you buy them? Do you produce them? Do you give them to others? Right? In order to be able to understand what's going on with just your data itself. So information architecture is a big one, but then also, what are your model interactions? What sort of models do you have? Should you? Well, the answer is probably yes to the should, but could you do a model registry right now?
Sarah, can you explain to people who are like really legally lawyer people and not technical at all, what is a model?
Sure. A model is the recipe for how we are going to combine the data. So what is it that we're going to do with our variables, our features? Are we going to push them through a linear form of mathematics? Are we going to push them through a non-linear form of mathematics? Are we going to create different forms of transformational architecture to where the data that we push in turns into something before we push it out? A model is just instructions. And that gets us into a bit of confusion because sometimes we call an algorithm a model, we call an algorithm instructions. You can think of them all as instructions for how to cook data. But how it is those models can be classified in terms of what your company does with those models, in terms of who built them, in terms of how they interact with one another, because it's really easy to say the model, right, or a model, without realizing that they're often a little bit more like organisms. They're components of modules, components of cells that build into something that turns into what we see on the end side, on the consumer side, the end user services. There's also questions then of, your information architecture, your model registries, but also what's your code, right? What is it you're doing in terms of the user interface that allows people to give you data through their interactions, or for you to serve them back decisions through the cooking of your data through the model?
Well, so here I am. I'm a lawyer. I'm approached by the data science team, or I hear that they're going to be using machine learning because we have consumer data I don't know, we have people visiting our website, some of which never come back, and others which purchase, others which commit fraud, and others which become very valuable customers. And we're going to look at them and what we know about them, what they do at the website, or the kinds of things they buy, or other data about them. And then we're going to come up with a recipe that says these are the users who are likely to be fraudsters based on what they first buy, or how they click on our site, or what zip code or IP address they're from, and these are likely to be the really good customers. So, you know, roll out the red carpet, or, you know, offer them a discount right away, or the like. So what do I look at? You know, so I want to make sure I'm complying now. This seems to be automated processing. I don't know, maybe this could be discriminating. What if only people from one ethnic group are the ones who are always put in the fraud bucket? And that is a variable. Where would I look? How do I see this if I'm a lawyer and I'm trying to do the compliance that perhaps the EU or some of these automated processing, you testified recently in one of the US states, because there are efforts to start with government first, right? I mean, if government's using algorithms to make decisions about providing services, you know, we ought to be saying in your procurement process, you need to do this right. So how do I get my hands around this? Can I read the code somehow and say, well, look, what does this stand for? This sounds like race, and it says, right, where do I start?
Sure. If I were to advise a lawyer who's going to go to their data science team today to figure out, is my model, is my data biased, I would start by asking the lawyer to invite the data science team to tell them, what are my most salient features? What are the variables that this model can't live without? Because those are the ones that are clearly going to be important drivers. And then looking at your most salient features, figure out, are those things that correlate with, for example, as you pointed out, protected classes? Or are they things that are potentially proxying protected classes? You brought up a couple of different examples that are often indicated as potential proxies. So perhaps your zip code or your IP address, or even the browser that you came in from, or the version of the browser that you came in from, all of those can be useful proxy variables. If those happen to be the features that your data scientists say this model can't live without, it's time to take a good look at those.
How do I even know whether something is going to be a proxy for something, right? So, hey, we've done this right, Dr. Jordan. We have no race in here. We have no ethnicity. It's just optimizing based on the best customers and the worst customers. Do I have to analyze? I mean, I guess we know that zip code and address could be, I mean, people are not, you know, distributed homogeneously around the world. I guess I know that, but I don't know. How do I know, if I don't know race, how do I know whether the browser is somehow using a bunch of signals that correlate high with perhaps income or race, if I don't know those bits of information?
Sure. So I think the biggest question about proxy variables that you're going to need to ask your team is to figure out where they, from where are they building their models, right? Are they building their models based upon, say, evidence-based practices from social science, from law, from health? Those domain-specific expertises are going to tell you what are often going to be the most important variables to drive things. So, for example, in healthcare models, is it your age? Is it your gender that may drive those things? If there's not a domain-specific expert there, you may need to ask your data scientist why. But you may also want to invite that person in, those experts on that particular model, to say, these are things that could be understood as proxying for things you may not want to.
Did you make a distinction in what you just said between what is supervised versus unsupervised? Is it fair for me to understand that if I've come in with this model because I know something about society and research and kind of this domain expertise, and I've built this in order to, in a sophisticated way, try to apply a theory, to a complex set of data. Is that supervised and unsupervised? I don't have a theory. I just see what optimizes. Correct me if I'm wrong there.
So there's a difference in terms of thinking for what is supervised versus unsupervised type of machine learning, right? Supervised machine learning says we know something about the output variable we want to measure. We know something about the class. We have labels. We have sort of truths attached to the data that we have. And we can figure out, does our model accurately predict that label, that truth about that we know is correlated with the data, or we expect it is correlated with the data. An unsupervised training system looks at the data and tries to find what are patterns within it that we then can interpret as truth. Your way of how you just described this is more of an inductive versus a deductive forms of approach. Obviously, something that is going to be an unsupervised model, you're looking from data to generalization. It is a bit more inductive, whereas a supervised model, it's a bit more deductive, where we're trying to figure out what is true there. There's different risks attached to both of them, though. As we know, supervised machine learning, the labels themselves may be wrong, they may be incomplete, and in some cases, they may not be wrong or incomplete internal to the data itself, but they may be wrong or incomplete for your particular application. You may be using data that is not well suited to what you have, to the problem that you're trying to answer. And that's a different form of risk.
So I know you've spent some time with others on the team and with a lot of our stakeholders, beginning to try to understand the proposed European Commission proposal. There's a lot in there, and it's a pretty complex document. So I don't think anyone has sort of kind of really done the here's the totality of what's happening there. But obviously, a lot of key ideas raised. What was your perspective? What are the initial ideas there that are going to need to be really thought and made more precise, or that that resonated well with you, or where you're like, how does that really work? Welcome your thoughts and reactions.
Sure. So I think, like everybody that read that the new EU regs, we went conformity assessment. Right, we're going to look at this through much more of a consumer protection lens. And then the moment we got done, I sort of Googling conformity assessment systems, we went back and said, okay, so how is it that these conformity assessments are going to emerge in the absence of standards that we can create conformity assessment against? So I think a big upshot for me is that there's a lot of work left to be able to make this work.
What is a conformity assessment?
A conformity assessment, at least internal to the EU regs, we need to figure out what the requirements are for a quality management system attached to your product, your machine learning project, your technical documentation associated with it, and making sure that those things are reviewed either by a third party or internal to the company itself. What I think is super critical about the EU regs is that it does create different tiers for understanding risk, and it attaches different forms of conformity assessment documentation and conformity assessment judgment based upon those risk tiers. So, for example, if you're engaging in remote biometric surveillance, your whole system, all the technical documentation, the quality management system, all those things that go into your CA certification need to be third-party assessed. That's going to introduce some interesting wrinkles for cost, where you find those third-party assessors, et cetera. If you're not doing something that falls into the high-risk category, you can essentially perform all the necessary documentation for the conformity assessment system to be judged by appropriate regulators, but it's not going to be external third-party forms of assessment with the associated costs attached to it.
So let me ask you this. When GDPR passed, many of us who've been working in this area a long time said, okay, there's some complicated stuff here that we need to think about, but most of what is in the GDPR was in national law, was in the European directive, and yes, new penalties, new fines, a couple of new processes. But I could look around and say, you know what, there are good players who already do almost all of this, and everyone else now needs to get up to that par. Or maybe no one is actually getting consent for all these things, but we know what it means to get consent. We know what it means to rely on legitimate interest. We know what it is to do a privacy impact assessment. So there was work to do, but nobody had to invent anything new, or, and there are places where standards for technology that could match up to what the legal requirements are, were helpful and are still being developed. Is it the case here that this law anticipates the creation of a whole bunch of sort of standards and processes that don't exist? Or is there anybody who you can point to, any researcher, any company who's doing some of this? I mean, there are companies today providing machine learning tools, providing all kinds of AI tools. Does anyone do already that we ought to be like, hey, we should live up to this best practice? Here's how we all now, or with some improvement, that does it? Or are we really going to have to build a whole new structure to even be able to comply? It feels like there's some problems that haven't been solved in the academic or researcher or business world around making sure machine learning is fair. People are still saying, I don't know how to do that. We're debating that in labs. Or are there places we can point to? Or what do you think?
Sure. So I think you mentioned what is probably the most important part of all of this is that none of this takes away the GDPR. Making sure that we are compliant with the GDPR, lawful basis, et cetera, doesn't go away, right? And that is an absolutely essential point that I think is sometimes lost in the weeds of talking about the rest of what came down in the EU regs. But a lot of the things are already in national law. What I think was interesting about this particular regulation landing is that it came out at the same time as the machines regulation. And in the machines regulation, they talk about all of those different forms of conformity assessment, harmonized legislation for creating those certification systems, those CA systems throughout the rest of the machinery that often uses artificial intelligence, often uses machine learning. And in particular industries, doing this is a normal part of business, right? You were already dealing with conformity assessment as a regular part. Now you need to do that for these software instruments, machine learning, et cetera, that goes into your machines. So that's not new, right? Doing it for this particular component is new. There are a couple of areas that I think, though, we have some good players already working in this space. And there are a lot of areas where there are things that exist in piecemeal that could be brought together to help people to make sense of this. Let's not forget that ISO and IEEE and CENELEC, et cetera, a lot of the standards bodies that exist in this computational space, in this technical space, have been working on standards appropriate to this for years now, for almost a decade in some cases. And hopefully what's going to happen with the reaction to the regulations is that many of these standards may come to fruition. There may be a new groundswell of support to get these done. So that way, the conformity assessment, the certifications that come after that can move forward. I'm really hopeful that it's gonna push us in that direction. But in terms of creating whole new cloth sorts of things, not necessarily, not as much as I think people initially were concerned about. There's a lot of stuff in here.
Lots of us lawyer, policy, legal, privacy types are going to need to understand the nuts and bolts of AI and machine learning better. What are you and Brenda on our team going to be doing to help educate people who want to perhaps, we can't go back to graduate school and we didn't do that well in statistics in the first place. What are you going to do to help us be a little smarter about the technology involved?
Absolutely. So next Thursday, we're holding our next Understanding Digital Data Flows class, where we're going to be talking about, understanding and governing artificial intelligence. And we're going to take it in 2 steps, right? How to understand your data, how to understand your information architecture, and then how to understand your model. How do you understand how you cook your data? What we're going to do here, though, is we're going to assume that everybody has read quite a bit about artificial intelligence to try to get smart, say, for example, on the EU regs, or to get smart for the automated decision bills. And we're going to start talking to people without statistics, but with a little bit more knowledge in terms of, how do you make sense of your information architecture? How do you read a data diagram as a lawyer to know what's happening to your data as it comes in. It's mixed together, it's recombined, it's pushed through these recipes, these models, to turn into the final product that you're trying to serve. And so without any statistics, we're going to do our best to try to give you a overview of what machine learning looks like in a no-code environment.
Super. And maybe a good look at a high-level picture of some of the building blocks is the really nice infographic that the team did that we'll post a link to here in the comments as well, just showing the different ways, different kinds of processes are used for different kinds of machine learning and the like. Anything else important that we should mention before we let people go to their busy days?
I think there's going to be a lot of traffic on the AI regulations. And I think there's going to be a lot of traffic over the summer in the United States about automated decision bills and how we're going to try to regulate those vis-a-vis ourselves and the GDPR. So stay tuned.
2 hours next week on Thursday, FPF.org. You see it at the top of the site. We also have a class coming up on de-identification if you want to sign up for that as well. These classes, just to level set, are not the law and policy classes. Those are important. Go take them, but you can take them. There's lots of places. There's law firm blogs. There's IAPP certifications. Lots of places that you should, we assume, and already are. What we're trying to fill in is that gap between what the engineer knows and what the lawyer knows. That's where I think all of us need to be kind of Renaissance people with a really well-rounded set of skills. So really delighted. Please take advantage of it. There's a modest fee. We like to feed our staff. I would like to eventually go to a barber, get a nice shave and a haircut, and we pay those bills. So modest fee, but very affordable. And we welcome your participation. I'll close just with, if you were letting out a breath of fresh air when I gave that little introduction, I will note that draft decision that Helen Dixon, had, it is the case that she said specifically. Let me read the language, because this is troubling, not unexpected. But she says in this PDD, if you're going to read the case itself, PDD, that was her draft decision, that U.S. law, the Court of Justice found that U.S. law interferes with the rights of data subjects under Article 7, 8, and 47 of the Charter. So she says in her draft decision that the court now says she can advance with the parties, it necessarily follows that SCC's, standard contractual clauses, cannot compensate for inadequacies in the level of protection afforded by U.S. law. Meaning, please do your last Facebook messages, your last WhatsApp messages, your last emails, your last communications with people in Europe in the next couple of weeks, because it's going to be carrier pigeon from there on. I'm kidding. I hope not, because I hope the U.S. government is watching, is listening, and that the negotiations between the European Commission and the U.S. government can bridge the divide that has been created here, which we don't think the court intended to create. We heard that from Justice Donowitz, that the court didn't intend to create a gap, but we may need to do some legal, legislative negotiations to continue to use machine learning data in ways that hopefully benefit society, subject to the European Union's guidance. All right, thank you so much. Please join us next week. Please do sign up. I'm going to sit in on this one. I'm going to take this class because I need to know more. And as you see, Sara is a phenomenal teacher. Thanks, everybody. Thanks, Jackson and Nancy in the background, for queuing us up. And have a happy Friday. Thanks for joining me, Sara.
Thank you. Have a good day, y'all.